Good morning, all of you. Welcome back to our class for Paper 2 Corporate and Other Laws. I hope all of you are doing well. And I know we meet after long, all of you, it becomes difficult to remember everything, discuss everything pertaining to who can be an agent, what are the rights of an agent, what are the liabilities of an agent, what are the liabilities of the principal towards the concept of substituted agent. So all of these concepts we had completed in the previous class. However, there was one topic that was left, which was revocation of authority. Okay, so in the previous class only I told you that the revocation of authority I will take up in this class. So I hope you remember what we had discussed in the previous class, because with a blank mind, with no concepts of the previous class, it would be difficult for you to understand what we are talking about in the revocation of authority. So once we are done with the revocation of authority, we will begin with the next topic or the next chapter for today, which is the General Clauses Act. Is that fine with all of you? Okay. So coming to revocation of authority. So we know that a person who is of sound mind and who has attained the age of maturity can duly appoint an agent to do anything which he can do. So what basically a principal does? He authorizes the agent to do certain things on his behalf, and anything which is done by the agent is treated to be done by the principal himself. So even though there is no direct privity of contract between the principal and the third party, but because the work has been done by the agent who is authorized, indirect privity of contract establishment where there can be a consideration or a situation where the authority could not be revoked. So what are those situations? What are those provisions under which an agency,
Recording in progress.
You can put in your answers in the chat box. What is meant by revocation? So what is meant by the word revocation? Revocation means to revoke, to take back. So the principal, because he has given the authority, he can take back the authority as well. So an agency may be terminated by the principal revoking the authority of the agent. And when and how can he revoke the authority? He can revoke the authority at any time before the authority has been exercised so as to bind the principal. However, the principal cannot revoke the authority given to his agent after the authority has been partly exercised so far as regards such acts and obligation as arise for acts already done in the agency. So what is meant here? There are two situations. So the common scenario is the principal has authorized an agent to do something. Now we are talking about revocation of authority. One, the authority that was granted has not been exercised till date. So at any time before the authority is used or exercised by the agent, the principal can revoke the authority and the third party would be bound by it. If the authority has been revoked, it has been communicated to the third party, still he enters into a contract with the agent, the principal would not be liable. Second situation is the principal granted the authority to an agent and agent has partly exercised that authority. Let's say the authority was to buy 1 kg of gold. Correct? So this Mr. A, who was the agent, he goes to the jeweler number 1 and buy 100 grams of gold from him. So what has happened? The authority has been partly exercised. Correct? Now, Immediately after this, the principal revokes the authority, but obviously 100 gram of gold has already been bought. So the quantum of area for which the authority has been exercised, for that the principal would be liable. For any future transactions, he will not be liable because the authority has been revoked. This is what is provided for in section 203 and 204 of the Indian Contract Act. So if we look at this example, A authorizes B to buy 1,000 bales of cotton on account of A and to pay it out of A's money remaining in B's hand. B buys 1,000 bales of cotton in his own name so as to make himself personally liable for the price. So what has happened? He did not exercise agency. He is buying the goods in his own name. So here A cannot revoke B's authority so far as regards payment for the cotton. So the agent has to act as per the authority and under the authority and has to be dealing on the account of the principal to be able to revoke the authority. Correct? Is this 204 clear? Section 203, 204 is clear? Is that clear? So now, because the principal is revoking the authority or there is a renunciation of authority by agent. So authority can be revoked by the principal or it can be renounced by the agent. Revoke means taking back. I have authorized, I am taking back. Renouncing means I have received it, but I am letting it go. People renounce the world. They leave the material affairs. So an agent can also renounce the authority that has been granted to him. However, if the principal is revoking the authority or there is renunciation of authority by agent, then if there is an early revocation or renunciation without a sufficient cause, there is a provision which requires that principal must compensate the agent for the same. But that all depends on the facts and circumstances of the case. So section 205 says, where there is an express or implied contract that the agency should be continued for any period of time. So the contract is such that there is a specific time period for which the agency has to be continued. So 205 says the principal must make compensation to the agent or the agent to the principal as the case may be. So what would be the case? If the principal is revoking the authority, he will compensate the agent. If the agent is renouncing the authority, he will compensate the principal. So, as the case may be, for any previous revocation or renunciation of the agency without sufficient cause. Now, what is this sufficient cause? Sufficient cause has been broadly and differently interpreted by courts. So, let's say if the agent does not has the required skill to perform a particular task, the principal may revoke the authority. So here there is a sufficient cause. There is a reason for revoking of authority. So where the revocation or renunciation is done without sufficient cause, in that case, whatever the scenario is, either of the parties will compensate the other for the early revocation or the renunciation. Correct? Is this clear? Is this section clear to all of you? So, whenever an authority is revoked or renounced, in both the cases, a notice of such revocation or renunciation has to be given. Otherwise, there can be damage that can be caused to the principal or the agent. So notice is always important. See, as if you take it generally also, if you have given some power to somebody and you're taking it away, so intimation has to be there. So this is what's the purpose for the section 206. Now further 207 says that the revocation and renunciation may be expressed or implied. So either it can be expressly said or it can be implied in the conduct of the principal or agent. So if you look at this example, A empowers B to let A's house. Afterwards, A lets it himself. Okay, so he had empowered B to let his house, in the sense rent पे चढ़ाने के लिए. Okay, so he later rents it himself. So this is an implied revocation of B's authority. So the first thing that we discussed here, the first situation first method of termination of agency is revocation by the principal or the renunciation by the agent, where it is a willful on its own, they revoke, or authority is revoked by the principal or it is renounced by the agent. So whenever there is a revocation or renunciation, if it is an early revocation or renunciation, as the case may be, either of the party will have to compensate where the termination has been done without sufficient cause. Second was, whenever the authority is revoked or renounced, notice has to be given. Third, this revocation or renunciation of agency can be expressed or implied through the conduct of the parties. Is that clear? Is this clear? Revocation and renunciation is clear to all of you? Now, so one is revocation of authority, second is the renunciation of authority by the agent. So renunciation will be done by the agent, revocation will be done by the principal. I hope you are not getting confused in these two words. Revocation is a different word, renunciation is a different word. Next way of termination of authority is the completion of business. When the business comes to is completed, the agency is automatically terminated. So let's say if a person is appointed to buy 100 grams of gold, when the gold is bought, the authority is revoked. Fourth case is death or insanity. So where the principal or the agent, either of them dies or either of them becomes insane. Insane means mad, lunatic. Then also agency automatically comes to end. Similarly, when there is a winding up of the company or dissolution of the partnership, then also the agency comes to end. However, whatever was done by the agent before his death, the principal shall remain binding for the same. Correct? Next is principal's insolvency. So where the principal has been adjudicated insolvent, then also the agency comes to an end. And next is on expiry of time. So where the principal agent relationship is for a fixed period of time, and that duration of time has come to an end, or the purpose for which the agency was made has been accomplished, then also the agency comes to an end. Is that clear? So these are the various situations on how the agency could be terminated. One is revocation, then renunciation, third, completion of business, fourth, death or insanity of the principal or agent becoming of unsound mind, insolvency of principal, and expiry of time. So revocation and renunciation becomes R square. C is completion of business. D is death. Unsound mind is lunatic. Okay, we can make it U. Insolvency I, and expiry of time. R square C D U I E. So this is a mnemonic that you can keep it in writing to remember. So revocation, renunciation, completion of business, death, unsound mind, insolvency, and expiry of time. These are the various situations under which the principal-agent contract comes to an end or it is terminated. So are we good till here? Are we clear till here, guys? Is this clear? Or any confusion? Please say yes or no. Okay, so there can be situations where of the land to be able to pay off the debt. Now, what has happened? The agent has direct interest in the debt. It is the agent who is liable to receive the payment. So in this case, the authority cannot be revoked to prejudice such interest until and unless, so there is an exception to it, if the terms of the contract expressly provide for termination of agency. So if the contract that has been entered between the parties, it expressly provides for termination for the agency, it is an exception. Else, where the agent himself has interest in the property, which forms the subject matter of the agency cannot be terminated to prejudice such interest. So is this clear? Guys, is this clear? The language can be a little tricky here, but I hope it's clear to all of you. Let's look at another example given here. A consigns 1,000 bales of cotton to B, who has made advances to him on such cotton, and desires B to sell the cotton and to repay himself out of the price the amount of his own advances. So here again, A will not be able to revoke this authority, nor it is terminated by his insanity or death. So here the agency becomes irrevocable. Is this section clear? Now, what happens, next section that we talk about is the effect of termination. What happens when a principal-agent relationship or a contract of agency is terminated? So, section 208 talks about such a situation. So, section 208 talks about when there is a termination of agent's authority as to the agent and as to the third person, what will be its effect? That has been provided for in section 208. Now, section 208 reads as the termination of the authority of an agent does not, so far as regards the agent, take effect before it becomes known to him. So, notice becomes important. The termination will take effect only when he is notified about it or it comes to his knowledge. So far as regards third person, before it becomes known to them. So the termination will become effective only when the agent and the third parties come to know about it. So let's say principal revoked the authority, but he did not inform the third party, and third party with the original old understanding that he is the agent enters into the contract. In that case, principal will be held liable. So notice becomes extremely important here. So if we look at this example, A directs B to sell goods for him and agrees to give B 5% commission. On the price fetched by the goods. A afterwards by letter revokes B's authority. B after the letter is sent but before he receives it sells the good for rupees 1 lakh. So the sale becomes binding on the principal and the agent will be entitled to his commission. Is this clear? Is this section clear? Look at another example. A at Chennai by letter directs B to sell for him some cotton lying in a warehouse in Mumbai, and afterwards by letter revokes his authority to sell and directs B to send the cotton to Chennai. B, after receiving the second letter, enters into a contract with C, who knows of the first letter, but not of the second. So he is aware that he has authority to sell the cotton, but he does not know about the revocation of authority. C pays the money to B, but B absconds. So here C will have no liabilities towards A because he had no knowledge of the revocation of authority. This is how this functions. Correct? Next section that we have to look here is section 209, which talks about the duty of the agent on termination of agency by principal's death or insanity. What will happen where the principal has died or has become insane and the agency has come to an end? So what is the duty of agent that has been provided for in section 209? So 209 says, when an agency is terminated by the principal dying or becoming of unsound mind, the agent is bound to take on behalf of the representative of his late principal all reasonable steps for the protection and preservation of the interest entrusted to him. So he will have to act reasonably to ensure that no unreasonable losses are caused to the principal. Correct? Section 210 talks about termination of sub-agent's authority. Correct? So 210 says, termination of the authority of an agent causes the termination of the authority of all sub-agents appointed by him. Correct? So whenever an agent is terminated, sub-agents also get terminated. So this is all about key sections for revocation of authority and effect of termination. Is this clear to all of you? Any confusion in these sections that we discussed today? Any confusion in these sections, guys? Because I'll start with General Clauses Act after this. So we can take 5 minutes. We have time till 7:30. Let me know if you have any queries or confusions on this part, on the topics that we have discussed, which is revocation of authority, that is termination of agency, and the effect of termination. Any queries in this topic? If you have queries, you can put it in the chat box. Okay, I think we are good to proceed. Students do not have. Okay, let's take 1 or 2 questions from here. So the first question is, can the following person appoint an agent? A minor who is of unsound mind, a lunatic who is a major, guardian of a minor who is of unsound mind, a lunatic who is a minor. Please type your answers for this. Please type your answers for this question in this chat box. Please type your answers, all of you. No, Rupesh, your answer is incorrect. So the first option that we have provided here is a minor who is of sound mind. Can a minor appoint duly, validly appoint an agent? Minor cannot. If the minor appoints an agent and that agent is major, the appointment is not valid because the minor is directly entering into a contract. A lunatic who is a major? Can a lunatic, who is a lunatic? Lunatic is a person who is of unsound mind. Can he validly appoint an agent? No. Guardian of a minor who is of unsound mind. So the minor is incapable of entering into a contract. Guardian, because he is of unsound mind, even he cannot enter into a valid contract. A lunatic who is a minor, no, even he cannot enter into a valid contract. So in all these cases, it will become the following, all of these people, none of these people can appoint an agent. Now look at this question. Shyam appoints Ram, a minor, as his agent to sell his watch for cash at a price not less than rupees 700. Ram sells it to Mr. Batra for rupees 350. Is the sale valid? Please explain the legal position of Shyam and Batra referring to the provisions of Indian Contract Act. Is this sale valid? Rekha, the presentation would be uploaded on the portal. In the first question, only one student gave the right answer, which was Harsh. Rest, everybody gave incorrect answers. Please put down your answers for question number 2. So what happens when a person of sound mind appoints a minor? With regards to the third party, the sale gets binding upon him, and because the agent has acted against the instructions of the principal, does the principal have a right or remedy against the agent? He does not have any remedy against the agent for the loss that he has incurred, right? So this will be the answer for this question. Srishti, your answer is incorrect. Only one student has given the correct answer, which is Hariharan. Rest, everybody has, Hariharan and Harsh. Both of these have given the correct answer. Rest, everybody has given incorrect answer. That's really bad. You guys are not studying. Next question. X, the principal, instructed Y, his agent, to put goods in Z's warehouse. Y puts half of the goods in Z's warehouse and the balance is in another equally safe warehouse. All the goods were destroyed by fire without any negligence on the part of Y. Is Y liable to X? Please tell me. Is Y liable to X? Please put in your answers in the chat box. I'm waiting for your answer, guys. Hariharan, your answer is correct. Harsh, your answer is correct. So the agent, which is Mr. Y, he will be responsible for the goods that he kept in another warehouse. That is half of the goods that he had put in some other warehouse. He will be liable for those goods because he did not act upon the instructions of the principal. And when the agent doesn't act as per the instructions of the principal and the loss is caused, he becomes liable to the principal. Correct? Is that clear? Look at this question. Explain whether the agency shall be terminated in the following cases under the provisions of the Indian Contract Act. First, A gives authority to B to sell A's land and to pay himself out of the proceeds the debts due to him from A. Afterwards, A becomes insane. Can this authority be terminated? Please put in your answer for this question. Please put in your answers for the second question. So what will happen here? Because he directly has the agent has direct interest in the subject matter of the agency cannot be terminated. Second question is, A appoints B as A's agent to sell A's land. B, under the authority of A, appoints C as agent of B. Afterwards, A revokes the authority of B but not of C. What is the status of agency of C? What will be the answer for this question? So when the authority of the agent is revoked, the authority of the sub-agents also get revoked automatically, correct? So because the authority of Mr. B is revoked, the authority of Mr. C also stands revoked, and any dealings or transactions done by him will not be binding. So these are the kind of questions that you get to see. There are more practice questions that I have put in here, but we don't have enough time to go through all of them. So with this, we complete our topic, which is revocation of agency. Yes, Harsh, your answer is correct. Hariharan, your answer is also correct. So I think we are good as far as the contract of agency is concerned. The next topic that we have to start with is the General Clauses Act, right? Everybody is ready to start with the next topic? No confusions here. So the next topic that we are going to start today is the General Clauses Act. All of you can see my screen properly? Okay. Yes, Khushi, your answers are reaching out to me. Yes, Khushi, your answer is correct. Your answers are correct, Khushi, don't worry. Okay, now please, all of you, stop focusing or putting your answers for the topic contract of agency. Now we are going to start the next chapter altogether, which is the General Clauses Act. So we are done. We have completed the chapter contract of agency, and the next chapter that we are going to start, which is a part of your syllabus, it will be General Clauses Act of 1897. Okay. Do I have everybody's attention? I know taking two different topics in continuation can be difficult. It gets difficult for you to focus sometimes, but just close your eyes for a minute and then reconcentrate yourself on this next topic, which is the General Clauses Act. Now, General Clauses Act, if we talk from your exam point of view, you can see questions from this topic also from 3 to 4 marks. So the questions are usually very, very simple. Sometimes they are direct questions also. Sometimes they are case study based questions also. Correct? General Clauses Act as such, if you know, there are all the sections that have to be covered. But in my class today, I largely focus on the most relevant or most important areas. So, you know, we have limited time. So I'll try my best to cover every section that has been provided for. However, depending on the availability of time, I might skip a few sections which are non-technical or extremely basic, or just a simple reading is required on them. But I'll definitely explain all of those areas which become extremely relevant and important from your exam point of views, or the areas from which we have been seeing questions in the past. However, we all know that ICAI makes questions from each and every areas. There is not a single area from where we do not because this act, when you talk about the General Clauses Act, it not only contains the definitions of certain terms, but it also contains certain rules of construction, certain principles of interpretation of any law. So this act is like a dictionary of acts which is applicable to every other law that has been made. Now this act, which is the General Clauses Act 1897, was enacted on 11th March 1897, and it consolidated two previous enactments of 1868 and 1887. So if you see, it's quite an old law. 1897 it was enacted. It has been more than 100 years since this law was enacted. And because it was made in the Britishers' time, it is very much modeled on the English Interpretation Act of 1889. Correct? Now, this General Clauses Act of 1897 is the central act, and it is applicable on every central rule and regulation. Similarly, we have State General Clauses Act also, which are used for state acts. So like there is a Karnataka General Clauses Act, there is a Maharashtra General Clauses Act. So wherever there is a requirement for seeking a definition for a state law, or aid is required in interpretation of state laws, then we seek out to the State General Clauses Act. This General Clauses Act is a central act, and it is applicable to all central acts and regulations. Is that clear? Is that clear, guys? Now, why is there even a need to study the General Clauses Act? Because General Clauses Act becomes extremely relevant when a particular term has not been defined in that act. So if a word has not been defined, a term has not been defined in the particular act, we look out for its meaning in the General Clauses Act. So we all know that the initial sections of the act, so if you take Companies Act also, section 2 is the definition part. If you look at Indian Contract Act, section 2 is the definitional part. But often there are certain terms which has not been defined in that particular act. And if you require the meaning of those terms, you look out to General Clauses Act for the meaning of those words. Correct? So, this is why it becomes extremely relevant for you to study the GC Act. So wherever there is a clarity of definition, or there is no definition that has been provided for, or there is a conflict between pre-constitutional laws and post-constitutional laws, in all those cases, the General Clauses Act becomes handy. Is that clear? Now, coming to the object of the GC Act. So the object of the General Clauses Act is to shorten the language of the Central Act, provide for uniformity of expression in Central Acts, provide for certain convenient rules for the construction and interpretation of central laws, and to guard against any slip and oversights. Slip and oversights by importing into every act certain common form clauses. So what they have done, instead of defining those common terms in each and every act, they made a separate act for it, where those common phrases that are used in multiple legislations have been defined and have been provided for. Is that clear? Are we good till here? So, talking about the purpose of the GC Act, so the Supreme Court, in the case of Chief Inspector of Mines versus Karan Chand Thapar, the Supreme Court said that the purpose of this act is to place in one single statute different provisions as regards interpretation of words and legal principles, which would otherwise have to be specified separately in many different acts and regulations. Now, supposedly, let's take this example. There is a word called affidavit. So the term affidavit has been defined in the General Clauses Act. Now, this word affidavit you will get to see in Companies Act also. You will get to see in Transfer of Property Act also. You will get to see in CPC also. You will get to see in CRPC also. Everywhere. So, instead of defining a particular word in each and every legislation, a separate legislation was created in which those general terms which are used largely have been specifically defined. Correct? So this was the purpose. So there was a case which was Anand Behra versus State of Orissa. In this case was pertaining to the Transfer of Property Act. Now the question was whether the right to catch fish is a movable property or immovable property, because there was a dispute pertaining to this. Now, the term movable property has not been specifically or clearly defined in the Transfer of Property Act. It only says that immovable property does not include standing timber, growing crops, or grass. So what it has done, it says what is not included in immovable property. It doesn't specifically define immovable property. So in this case, the court referred to Section 3, Section 26 of the GC Act, which defines the word immovable property. What does it say? Immovable property shall include land, benefits to arise out of land, things attached to the earth, or permanently fastened to anything attached to earth. So the courts referring to this definition said that since catching of fish is a profit arising from the land, it is a profit of prendre, it will be regarded as a immovable property. So the courts said that the right to catch or carry fish is a immovable property. So this is how GC Act comes to rescue to the courts. Is this clear? Okay. Before I proceed further, there is one thing that I would like to tell all of you. Whatever is written in this presentation is from your study material only. I see that a lot of students are mostly worried about the notes. Ma'am, notes are not available in the download section or things like that. Please let me tell you, when I am teaching you in the class, you are requested to focus on the content that I'm delivering. Notes will any which ways be made available. If they are not available now, they will be available in a while. It will be available tomorrow. They are not going anywhere. And if you have study material by ICAI, you don't require anything as such. Those study materials are more than enough. So kindly do not invest your time and energy on searching for notes while I'm taking the class and putting queries in the chat box pertaining to notes. Those queries we can always take up in the end of the class. You are requested to focus on what I am teaching. If you are able to understand, if you are able to figure out the concepts, any which ways when you read the study material, you will get everything clear. And the notes will be uploaded. By putting regular queries for notes and presentations and PDFs, you really distort the flow of the class. I request all of you not to do something like this. Please understand, as a faculty, we are switching between two windows, between your chat box and presentation, so that we are able to take your queries also. It really distorts the entire flow of the class. So all of you are requested to focus on what is being taught in the class. Is that clear? Everything that is written in my presentation has been taken from your study material itself. There is nothing new that I'm talking about. So, okay. So how the General Clauses Act comes to the rescue while interpretation of laws, that is clear to all of you? Okay. Now, coming to the application of the General Clauses Act. So generally, you will see a lot of acts has a territorial extent provision. So earlier we used to see that the particular act is applicable to entire of India except to the state of Jammu and Kashmir. You get to see such kind of things, right? But this GC Act does not have a territorial extent clause. It does not define the territories to which it is applicable, but it definitely lays down to what all central acts and regulation it will be applicable. So the General Clauses Act is applicable to all the central acts. And what are those central acts to which it is applicable? One, acts of Indian Parliament along with the rules and regulations that are made under the Central Act. So any act that has been made by the Parliament of India along with their rules and regulations, to them the General Clauses Act is applicable. Acts of the Dominion Legislature. So Dominion Legislature was the legislature that was in existence between our independence and before the Constitution of India came into force. That is the duration between 15th August 1947 to 26 January 1915. So whatever legislatures were made during this term, to them also the GC Act is applicable. Act passed before the commencement of the Constitution by the Governor General in Council or the Governor General acting in legislative capacity. So before the Constitution came into picture, there was a concept of having Governor General in Council. So this Governor General in Council had the power to legislate laws. So if there were laws that were legislated by the Governor General in Council, to them also the GC Act becomes applicable. Correct? Further, it is also used for the interpretation of the Constitution of India also. So Article 367 of the Constitution of India says, unless the context otherwise requires, the GC Act 1897 shall, subject to any adaptation and modification that may be made therein under Article 372, apply for the interpretation of this Constitution as it applies for the interpretation of an act of the legislature of the Dominion of India. So GC Act is equally applicable for the interpretation of Constitution of India as it is applicable for interpretation of the central acts of the Dominion of India. Is that clear? Next thing that we have to see is the applicability of the General Clauses Act. So one of the very, very unique feature of the GC Act is that in every section it provides for its applicability. So we know generally all acts are applicable prospectively, right? So if this act came into force on 11th March 1897, it will be applicable on every act, rules and regulation that were made after 11th March 1897, correct? But under few circumstances, under few scenarios, certain provisions of this act are applicable retrospectively also. So that has been provided for in section 3, 4 and the respective headings also. So section 3 of the General Clauses Act is the definition section, right? It talks about the definition. So section 3 of the GC Act, it is applicable to all central acts and regulation that were made after the amendment of GC Act 1897, that is after 11th March 1897. Section 4 lays down that there are certain definitions in section 3 that may be applicable to central acts that were made on and after January 3, 1868 and to regulations that were made after January 14, 1887. So what has happened here? There is a retrospective application. Section 4 says that there are certain specified definitions. There are certain terms. So those terms have been specifically mentioned in section 4. And it says that the definition of these terms will be applicable to central acts that were made on and after January 3, 1868 and the regulations that were made after January 14, 1887. So whatever acts and regulations were made after these duration, to them also certain terms, their definition will be applicable as provided in section 4. Other than that, applicability of each section has been provided in the respective section of the GC Act. As we read it further, you will get to know that. Is that clear? Any confusion on this part here in terms of applicability? Any confusion? Please let me know. So do not get confused here. Section 3 of the GC Act contains the definition. Okay? Obviously, an act, whenever it comes into force, it is applicable to legislation that comes into picture after that. So yes, all the sections, all the words that have been defined, they will be applicable to all central acts and regulations that have come into force after the GC Act. However, there will be, section 4 says that there are certain terms, certain words that have been defined whose definition will be applicable to central acts that were made on and after January 3, 1868 and regulations that were made after January 14, 1887. So this retrospective effect of GC Act has been provided for in section 4. Is this clear? Hariharan, is this clear now? Now, coming to some basic understanding, next section, topic that we pick up is basic understanding of legislation. So if you look at any act, it has several parts to it. The first part, you will get to see the index, then you get to see the preamble, the long title, the short title, the definition, the appendix, right? All of these are different parts. So one of the important component is of the act, any bare act you pick, it will always contain a preamble. Even the Constitution of India is preamble, has the preamble. Have you read the preamble and the Constitution of India? If you see, it very much tells you the crux of the Indian Constitution. Right. Similarly, the preamble of every act tells you the crux of those acts, the purpose for which the act was brought into picture, the reason behind it. Right. So whenever there is any confusion pertaining to interpretation of an act, the judiciary often looks into the preamble. So if you look at the preamble of the Negotiable Instrument Act, it says an act to define and amend the law relating to promissory note, bills of exchange and checks. So the Negotiable Instrument Act is an act which defines and amends the laws relating to the promissory note, bill of exchange and check. So if you have read the Negotiable Instrument Act, you would see these are the 3 types of negotiable instrument that has been provided for. Correct? Similarly, if you read the preamble of the Companies Act 2013, it says an act to consolidate and amend the laws relating to the companies. So preamble basically tells you about the intention of lawmaker behind the act. What was the purpose of the act? And it is an accepted aid for the construction of the act. But we look at the preamble as an aid of construction only when there is a ambiguity. Whenever the act, whenever the language of the legislation is clear, it is unambiguous. In that case, you do not look out to preamble for interpretation. Correct? So the preamble very much discloses the intention of the legislature, and it can be brought as an aid to construction only if the language of the statute is not clear. However, it can never have a overriding effect. It can only act as an aid of construction, but it can never have a overriding effect. Correct? Is that clear? Another important part of any legislation that you get to see is the definitions part. So what are those definitions parts? So there are a lot of terms which are repeatedly used in an act. Those terms are predefined and they will be used for the interpretation. So if you look at the Companies Act, it contains a list of definitions. The definition of the word company, body corporate, there are so many words that have been defined. So the meaning that has been assigned to it, the same meaning will be used and throughout the legislation, correct? However, sometimes we get to see there is a cross-referencing also. In the Company Act itself, you would have seen that Company Act refers to the Securities Contract Regulation Act for the meaning of the word security. It refers to the Information Technology Act for the meaning of the word digital signature. So it is permitted to cross-refer to a legislation for the definition of a particular word. Correct? Generally, these definitions are provided for in section 2 or 3 of the particular act. And when a particular definition is not provided for in that statute and a word needs to be interpreted, then they can be taken from the General Clauses Act. Correct? Is that clear? Now, whenever we look at definitions, there are certain words that are repeatedly used. So one of such concept is the concept of means and include. So when you read the definition, you will often see the usage of the word means and usage of the word include. So either it is means or it is include, or it can be means and include both. So whenever a definition contains the word means, that means it is the exhaustive definition and it specifically defines the term. Correct? It specifically tells you what is meant by it. So if you look at the definition of immovable property that was given in the Transfer of Property Act, it used to say immovable property does not include standing timber, growing crops, things like that. Correct? But when it says the word means, that means it specifically defines the term. So if you look at the definition of company as given in section 2 subclause 20, it states company means a company incorporated under this act or under any previous company law. Similarly, 234 defines the term director as director means a director appointed to the board of a company. Correct? So it specifically tells you what is meant by that particular word. Specific definition has been provided. Other than that also, there are definitions which contains the word include. So when a definition has the word include, that means it's a inclusive definition. It does not define the word as such, but it tells you what all is included within that definition. Correct? So if you look at the word debenture, it says debenture includes debenture stock, bonds, or any other instrument of a company evidencing a debt, whether constituting a charge on the assets of the company or not. So it says A, B, C, and D are included within that term. It doesn't define the word as such. So this is how the term include functions. Similarly, there can be some definition where the words means and include both are there. So such kind of definitions are called the extensive definition. Correct? So they are extensive in nature. So this was the concept of means and include. Other than that, another common terms that you get to see in the legislation is the usage of the word shall and may. So wherever the word shall is used, there is a presumption that it is mandatory in nature. And wherever the word may is used, there is a presumption that it is directory in nature, or it is a enabling provision. However, under some circumstances, the words may be interpreted differently. The word may be sometimes be interpreted as being mandatory in nature. So if you look at this, 13 says a company may be formed for any lawful purpose. So what does this say? May be formed. So generally what is meant by the word may, whenever the word may is used, it is generally said that it is directly in nature. That means it is not mandate. But do we interpret such an interpretation from lawmakers? So here the word may is interpreted as shall. That means it is mandatory that a company can be formed only for lawful purposes. A company can never be incorporated for anything which is unlawful or illegal in nature. So generally the word shall implies being mandatory and the word may is being implied as free, but in some circumstances they can be interpreted differently. So if we look at another example, Section 21 of the Companies Act provides that documents proceeding requiring authentication of contracts made by or on behalf of the company may be signed by any KMP or an officer of the company duly authorized by the board in this behalf. So here may is used understood as being directory in nature only. Correct. So there was a case which is Sainik Motor versus State of Rajasthan. In this case, Justice Hidayatullah, you observe that the word shall is ordinarily mandatory, but it is sometimes not so interpreted if the context or the intention otherwise demands. So generally the words shall is mandatory, but if the intention is something else, the context demands something else, in that case they may be interpreted otherwise. Is that clear? Is that clear? So this was some basics on the General Clauses Act. And now we will start with the Act as such, where it contains all the sections that has been provided in the legislation. Now, before I proceed with this, let me know if you have any confusion till here. Students who are asking me questions of Company Act, please let me tell you, discussing Companies Act is as of now beyond the scope because I have limited time and I have to complete the GC Act. I do not have enough indulgence to be able to discuss the provisions of the Companies Act with you. But I'm assuming that entire Companies Act has already been dealt, and this queries pertaining to the difference in the directors of 1956 and 2013, these things you can read on your own as well. There's nothing that needs to be discussed in the class. Okay? Is that clear, Rupesh? Okay. Any confusion on the basics that we discussed till now? Okay. So before we proceed on the sections from the GC Act, what we can do, we can take a 10-minute break. It's already 8:06 now. We can take a 10 minutes break, meet again at 8:15, and then start with the sections one by one. Okay, so we'll take a quick break of 10 minutes. In that time, you can go through the topics that we have discussed, and then we will take up each of the sections one by one. Okay. Okay, so it was a good break, right? Time to recollect, rethink, reorganize ourselves, and then start and come back to the class. Okay, so this chapter of yours has been divided into different parts. So if you look at the General Clauses Act, there are different parts to it. The preliminary part, which contains the short title, long title, the definitions and their applicability has been provided for in section 324A. General rules of construction has been provided in section 5 to 13. Some rules pertaining to the powers and functionaries has been provided in 14 to 19, and provisions as to orders rules have been made in section 20 to 24, and there are some miscellaneous provisions that has been provided in section 25 to 30. So all in all, it's a tiny legislation with only 30 sections. But yes, when you look at section 3, there are a lot of definitions that have been provided that we will take up one by one. Okay, so section 1 gives the short title, which is that it will be called the General Clauses Act. Long title says it is an act to consolidate and extend the GC Act 1868 and 1887. Section 2 has been repealed, and section 3 contains the definitions. So the definitions of certain key and important terms, I'm not taking each and every definition, but yes, I'm definitely taking the ones that are definitely technical in nature and that I really need to explain you in the class. So when you see the word act that has been defined here, pay attention, it is small a, not a capital A. So when it is a capital ACT, that means we are talking about the law, the legislation. Here the ACT, small ACT act that we are talking about, it means an offense, an act. An act means an action, correct? So it can be an offense or a civil wrong, it can be a series of actions. An action or omission, both are considered as the act. So let's say it is your responsibility to file return. You did not file return. So what is it? It is a omission on your behalf. Correct? Or you did not take the action. So the action, the omission, both are contained in this definition. Next is the word affidavit. So affidavit shall include, so if you look at this definition, it says shall include affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. So basically, it is a written statement where you affirm on certain facts. Let's say when we file trademarks, we put in an affidavit of usage. So what do we mention there? That this particular mark has been used from this particular date. So we are affirming a particular, declaring a particular fact through our signatures and before an authority. So lying on an affidavit is a crime. Correct? Never lie on an affidavit. So if you have written something in the affidavit, you have to be bound by it. You are declaring it, you are swearing it, you are affirming to it. Next is the definition of the word Central Act. So Central Act shall mean an act of parliament and shall include. So it specifically tells you what is meant by Central Act. It means an act of parliament. What all is included within the Central Act? It also includes act of dominion legislature and an act made before such commencement by the Governor General in Council or the Governor General acting in legislative capacity. Correct? So it not only tells you what is meant by this, but it also tells you what is included within it. So whenever the definition contains the word means or shall means, it is explanatory and restrictive. Correct? But where it also includes the word include and shall include, it enlarges the meaning of the defined word without taking there. You write Negotiable Instrument Act, when you write General Clauses Act, you always use the capital ACT Act, correct? That means, see, both the words capital ACT and small ACT, it is the same word, act and act, but the word act that the legislation has defined. It does not define the word capital ACT that we use for law. It defines the word action. The act that has been defined is not the act legislation, law wala act, but it defines the act meaning actions. That is all you need to focus. Don't focus on capital A or small a. Is that clear, Tarnu and Kanishk? Is that clear? Now coming to the next definition, which is commencement. So obviously we know that drafting of legislation, passing of it by the both houses of parliament, receiving the assent of the president, there are series of steps involved in making of a legislation or from the area where a bill gets converted into a law. So obviously the bill is drafted, it is proposed in the parliament, it needs to be passed by both the houses of the parliament, and once it has been passed by both the houses of the parliament, it has to be signed by the received assent by the President of India, and then it gets published in the official Gazette of India. However, coming into force of an act is different from making of a legislation. So an act can be made today, or it might be receive the assent of President of India today, but it might come into force later. So if you remember Companies Act 2013 also, initially only Section 1 came into force, and the remaining came into force in phases or parts. So whenever we understand the word commencement with respect to an act or regulation, it means the day on which the act or regulation will come into force. So it can, an act as such, a legislation as such, it cannot come into force, or it cannot come into operation without a legislative enactment. So basically what happens that once it receives the assent of the President of India, it gets published in the official gazette. So either it will come into force on the date it is published in the official gazette from the midnight, or the specific date that has been provided for in the law. The act itself can say that it will come into force on 26 January 1999 or XYZ, anything. Correct? Next is the word document. So what is the word document is defined as document shall include any matter written, expressed, or described upon any substance. So anything which is written upon any substance is a document. It also includes by means of letters, figures, or marks, or by more than one of those means. So this matter which is written on any substance, it can be written by any means of letters, figures, or marks, which is intended to be used or which may be used for the purpose of recording that matter. So whenever any matter or content is written, expressed, or described on any substance by means of letters, figures, or marks, or any of those means, and it is intended to be used for the purpose of recording that matter, such a thing is called a document. It can even be a leaf on which a matter has been written. But currency note is not treated as a document. It's a legal tender. It's not treated as a document. Next is the word enactment. So when we say the word enactment, it does not only include the act as such, it also includes regulations, any regulations that were made by the presidency towns of Bengal, Madras, or Bombay Code, any provision that is contained in the act, any rules, all of these are regulations. So are considered as enactment. So be it the law, be it the rules made thereunder, be it the regulations made thereunder, all of it is included within the word enactment. So enactment is a bigger word which is having multiple species. Is that clear? Now, next is the definition of the word financial year. Please mark this as important. You get to see questions from this definition. So financial year shall mean the year commencing on the first day of April. So what is the duration of a financial year? 1st April to the 31st March of the next year. What is it? How do you reckon the calendar year? Calendar year starts from the 1st January and ends on 31st December. So whenever we are talking about financial year, that means we are talking about year commencing on the 1st day of April. Okay? But always remember that we resort to this definition of financial year only when the word financial year has not been defined in that particular act. If the act or the legislation that we are reading, if it defines the word financial year, we will refer to that definition. Only in the absence of the definition provided in the legislation, we resort to the General Clauses Act. Always remember this point. The first-hand reference is always the sections, definition section of that particular legislation. Only when the word financial year is not defined in that legislation, we will cross-refer to the GCA Act. Okay. Next is the word good faith. So good faith is anything which is done with honestly and with diligence. If a thing is done negligently, even though there was no intention behind it, if there is negligence in it, okay, mens rea is absent, intention is absent, but negligent is negligent in good faith. So anything which is done with due care and attention, which is not malice, malice means bad faith or bad intention, is presumed to have been done in good faith. So for example, an authority is not acting honestly where it had a suspicion that there was something wrong and did not make further inquiries. So to be acting in good faith, one must act honestly also, and one must act diligently also. If one is acting in negligence, it is not considered to be good faith. Okay. Next is the definition of the word immovable property. So mark this important. The concept of movable property and immovable property is also very important. You often get to see questions here also. So GC Act says immovable property shall include land, the zameen, the land as such, benefit to arise out of land, and profit apparent. So what is the benefit to arise out of land? So let's say there is a land which has some mines in it, gold mine in it. So what is it? Benefit to arise land. Let's say the right to grow crop. So for growing crop, you need the land. It is a benefit to arise out of land. Things attached to earth or permanently fastened, anything attached to earth. So what is a house? House is permanently built on earth. It is attached to the earth. What is a tree? It is the thing that is attached to the earth. You cannot just uproot a tree like this, right? It is tightly attached. So immovable property shall include land, benefit to arise out of land, and profit apparent, things attached to earth, or permanently fastened, anything attached to the earth. So if you look at this definition here, it is inclusive in nature. Correct? So there was a case which was Shantabai versus State of Bombay. In this case, the question before the court was whether the tree is a movable property or immovable property. So the court held that the tree must be regarded as immovable property because they are attached to or rooted in the earth. Similarly, an agreement to convoy forest produce like tendu leaves, timber, bamboos, etc., soil for making bricks, right to build on and occupy the land for business purpose, right to grow new trees, to get leaves from the trees, to grow in, are all included in the term movable property. Because what are these? These are the benefits that are arising from the land. So whatever are the benefits arising from the land, they will be treated as a immovable property. Is that clear? Is that clear? Next is the definition of the word movable property. So movable property shall mean, so if you pay attention, shall mean property of every description except a movable property. So anything which is not a immovable property, it is a movable property. This is how it has been defined in the Act. Are we good till here, guys? Any confusion in the concept of movable and immovable property? Congratulations, Srishti, on clearing both the groups in first attempt. Guys, any confusion with the concept of movable and immovable property? Okay, let's proceed further then. Next is the definition of the word imprisonment. So section 3 subsection 20 subclause 27 says imprisonment shall mean imprisonment of either description as defined in the Indian Penal Code. So what is that doing? It is referring to the Indian Penal Code. The definition says imprisoned will mean those two types of description that has been provided for in IPC. What are those? Simple imprisonment and the rigorous imprisonment. Rigorous imprisonment is with labor. Simple imprisonment is just imprisonment without any labor or work. Next is definition of the word Indian law. So GC Act says Indian law shall mean any act, ordinance, regulation, rule, order, bylaw or other instrument which before the commencement of the constitution. So that means which were made before 26 January 1950, which before the commencement of the constitution had the force of law in any province of India or part thereof, or thereafter has the force in law in any part A or part C state or part thereof, but does not law include any act of parliament of the United Kingdom or order in council, rule or other instrument made under such act. So what it is saying, Indian law is any act, ordinance, regulation, rule, order, bylaw that were made before the commencement of India and had force in part A and part C states. But if the law were made by the Parliament of the United Kingdom or they were by an order of the council, which is by the British Queen, then it will not be considered as the Indian law. This is what has been given here. Next is the definition of the word month. So month means the month as provided for in British calendar. So some months are for 30 days, some months are for 31 days. But if you look at the word month that is occurring in section 271 of the income tax, it was construed to mean a period of 30 days and not a month as defined in the General Clauses Act. So for the Income Tax Act, a month means the period of 30 days. But if you look at GC, it means the month as provided in the British calendar, right? So how do you calculate this month? How this calculation has to be done? That has been prescribed from in Hasbury's Law of England. So it says when the period prescribed in a calendar month running from any arbitrary date, the period expires with the day in the succeeding month immediately preceding the day corresponding to the date on which the period starts. So let me explain it to you like this. Let's say we have to count, today it is 27th February, right? We have to count 2 months from today. So when will the 2 months come to an end? Please tell me. What will be the answer? How do you count 2 months from today? Please put in your answer. Yes. Correct answer, Sandeep, 27th April. So this is how you calculate the months part. So I'm not getting into too much of details here. Next is the definition of the word person. So for GC Act, the month when we talk about it is the calendar month. Okay. Next is the definition of the word person. So it says person shall include any company or association or body of individuals, whether incorporated or not. So if you look at this, the definition is little different. It tells you what is included within the word person. So if it is a company, if it is an association, or it is a body of individual, irrespective of the fact it is incorporated or not, it will be called as a person. Okay? Is that clear? Parth, before I give the question to your answer, you have asked me, ma'am, whether Indian Penal Code is an act or law. I would really want you to read what is the difference between act or law and come to me on this. And then we will discuss this question. You can take my email ID and you can drop me an email on that. Okay. Now coming to the applicability of the definitions. So there are certain definitions so all these definitions that we had discussed, they are defined in section 3. So obviously the definition will be applicable to all acts and regulations that were made after coming into force of General Clauses Act. However, there are certain definitions which have a retrospective effect also. That has been provided for in section 4. So it lays down, the first subclause lays down certain definitions that will be applicable to central acts made after 3rd day of January 1868 and regulations made on or after 14 January 1887. So every central act that were made after 3rd January 1868 and regulations that were made on or after, pay attention to these words, on or after. So when we say central act, we are saying, just 1 minute. So whenever we are saying central act, we are saying central act made after the 3rd January. When we are talking about regulation, we are saying regulations made on or after. So if a regulation was made on 14 January 1887, then also General Clauses Act will be applicable. So these are the terms whose definition will be applicable to central acts that were made after 3rd January 1868 and regulations that were made on or after 14 January 1887. Like the words like affidavit, immovable property, imprisonment, month, movable property, oath, person, You can read this. Okay. Further, subsection 2, if you look at it, it provides for certain definitions that will be applicable to all central acts and regulations that were made on or after 14 January 1887. So these terms, which is commencement, financial year, offense, registered, schedule, subsection, writing, the definition of these terms will be applicable to all central acts and regulations that were made on or after 14 January 1887. Correct? Is section 4 clear? So section 4 is nothing but it talks about the application of the definitions that have been given in section 3 to the previous enactment, that is enactments that were prior to the General Clauses Act. So it basically talks about the retrospective applicability of certain definitions that have been given in section 3. Is that clear? Any confusion with section 4? Guys, any confusion with section 4? It's an important section. 3, 4, these are all important sections. Okay. Next is section 4A. So section 4A talks about application of certain definition to Indian laws. What were the Indian laws? Indian laws were the laws that were into force. Laws means any acts, rules, orders, bylaws, regulations, ordinance, anything which were in force prior to the commencement of constitution in the part A or the part C states, except the law that were made by the council or the Parliament of UK. So all of these are the Indian laws. So section 4A talks about application of certain definition to Indian laws. What are these terms whose definition will be applicable to Indian laws? So the expressions like Central Act, Central Government, Gazette, Government Securities, Indian law and Official Gazette. So these terms, the definition of these terms will be applicable to Indian laws unless there is anything repugnant in the subject or context to all Indian laws. Correct? Is that clear? So are we good with this? Any confusion still here, guys? The next we talk about general rules of construction. So first general rule that we look about is section 5. Mark this important. You get to see case study based questionnaires. So section 5 says where any central act has not specifically mentioned a particular date to come into force. So when I was talking about enactment, I told you an act comes into force either on the day that has been specified or it shall be implemented on the day on which it receives the assent of the President of India. So because it's an old legislation, it mentions the Governor General. But now we have to remember, which receives the assent of the President of India and gets published in the official gazette. So the Companies Act 2013, it received the assent of the President on 29th August and was notified in official gazette on 30th August with the enforcement of section 1 of the Act. So the Companies Act came into force on the date of its publication in the official gazette, which was 30th August 2013 was the date on which it commenced or it came into force. So further it says where if any specific date of the enforcement is prescribed in the official gazette, act shall come into force from such date. Provision is also at times made for appointment of different dates for coming into force of different part of the same act. This is something which we have already seen in the Companies Act. The Companies Act came into force, it came into effect in phases. So initially on 30th August, only section 1 came into force. Then there were few sections. Then there were few sections. So there it is absolutely fine that an act can come into force in phases. Also, law does not take cognizance of the fraction of the day. So where an act provides that it is to come into force on the first day of January, in that case, the moment on 31st December night, the moment the clock will strike 12, the act will come into force. Correct? So this is how the commencement of an act prospectively for the future. However, there can be express words to have a retrospective effect also. That means if an act comes into force today, it will be applicable everything that happens in future from today or thereafter. But there can be a situation where there can be a provision for retrospective application. That means the application of an act. So something that has already happened in the past. Correct? So all laws which affect substantive vested rights generally operate prospectively. What do you mean by substantive vested right? A major amount of right, if it has been vested, it has been given to somebody under act, such acts operate prospectively. And there is a presumption against their retrospectivity till there are express words giving retrospective effect. So a law can have a retrospective effect only when it has been specifically provided for. So if you see, some definitions of GC Act are applicable retrospectively. So we have a specific provision, which is section 4 and section 4A, which creates the retrospective application. Is that clear? Is that clear, guys? Any confusion till here? Let me know, say yes or no. Is that clear? Okay, Tanu is asking me, ma'am, what is the meaning of repugnant? Repugnant means something which is contrary to something. Let's say law A says ABC, but B says DEF. So where there is some conflict or something contrary that has been provided for. So let's say the act says that 2 people have to be appointed, but in the section of appointment it says 3 people have to be appointed, right? So this is how repugnancy functions. Is that clear? Okay. Next is the concept of repeal. Please mark this, very, very important. Repeal and the effect of repeal is something that we often get to see. So if you see the General Clauses Act also, section 2 has been repealed. Now what is meant by the word repeal? Repeal means it has been taken off. It will be deemed as if it never existed. It is obliterated. When we say that an act, a section, a legislation, a rule, a regulation has been repealed, that means we are trying to say it has been obliterated and it will be deemed as if it never existed. वो था ही नहीं. It was never known. So if you see, Companies Act 1956 was repealed and Companies Act 2013 came into force. Now let's take an example. Let's say somebody committed some fraud during the reign of Companies Act 1956 itself. So Companies 1956 was in force and the director of the company committed the fraud, correct? But it never came to the knowledge. It came to the knowledge of the company or the MCA only in January 2016 or January 2019, correct? So the offense was committed when the Companies Act 1956 was in force, but it came to the knowledge, it came to the light only in 2018 when Companies Act 2013 is in force. Now, I'm saying when an act or rule or legislation is repealed, it means it is obliterated. It is deemed as if it never existed. It is wiped out from the books. In that case, how do you think the person will be prosecuted who has known to commit a fraud, even though that fraud was committed back when the Companies Act 1956, but it has come to a knowledge now? How do you think that person will be prosecuted? So this person will be prosecuted as per Companies Act 2013 because obviously Companies Act 1956 is no more into existence. It is obliterated. It is deemed as if it never existed. So because that fraud has come to the knowledge now, it will be determined, or the punishment or the penalty would be determined as per the Companies Act 2013. This is what is meant by repealing. Is that clear? Repugnant means conflict, Sushil. It doesn't mean against. There is some conflict, there is some other provision, a different provision. Is that clear? Parth, I'll take up your query in the end of the class. This is not relevant to what we are discussing as of now, but at the end, I'll take up your query. Don't worry. Is the concept, is the meaning of the word repeal clear to all of you? Please pay attention to this topic. It is extremely important. You always get to see question from this topic. Effect of repeal is one of the favorite questions of ICAI. So the meaning of repeal is clear to all of you. So there is a difference between repeal and deletion. So if a particular provision is deleted or omitted, it stops from existence from the day it has been deleted. For the past, it will remain as such. But when a provision is repealed, when an enactment is repealed, when a law is repealed, it is deemed as if it never existed. So there is a difference between repeal and deletion or omission. Repeal and deletion are two different concepts. Is that clear? So when a provision is deleted, it ceases to have effect from the day it gets deleted. But where a provision is repealed, it is deemed as if it has never existed. Always remember this. Do not get confused between the term repeal and deletion. Okay. Now talking about effect of repeal. So what is repeal? You know, repeal means when a law is repealed, it is deemed as if it never existed. It's an act which abrogates or obliterates an existing statute. Correct? Now, however, section 6 says there are some areas which receive protection. There are some areas, some rights, some liabilities that will not be affected because of repeal. So section 6 says, where any central legislation or any regulation made after the commencement of this act repeals any act made or yet to be made, unless other purpose exists, the repeal shall not revive anything not enforced or prevailed during the period at which repeal is effected. So if an act is being repealed by another act, it will not revive anything not enforced or prevailed during that period. Now let's take an example. Companies Act 1956 was repealed and replaced by Companies Act 2013, correct? Companies Act 1956 did not make CSR as a mandate. There was no mandatory provision for CSR. Neither there was any accountability, correct? Nor there was a mandate to spend 2% of the profit, net profit, correct? But when Companies Act 2013 came into force, it made CSR a mandate for the company, correct? 2% of the net profit was to be spent for CSR purposes, and the disclosure was also to be made in the director's report. Now, can the lawmakers or the MCA say that in the past you did not fulfill the CSR provision? Now the Companies Act 2013 has come into force and you have to? No, because it cannot revive anything not enforced or prevailed during that period. So when the Companies Act 1956 was there, CSR provisions were not applicable. They will become applicable only after coming into force of the Companies Act 2013. This is what is meant by revive anything not enforced or prevailed during the period at which the repeal is effected. So the repeal shall not revive anything not enforced or prevailed during the period at which repeal is effected. Second is, the repeal shall not affect the prior management of any legislation that is repealed or anything performed or undergone. So let's say, as per the Companies Act 1956, certain powers were with the ROC. Now in 2013 Act, they have been passed to the regional director. So anything that was done, the prior management that was done under the previous legislation, that will not be affected. So the repeal shall not affect the prior management of any legislation that is repealed or anything performed or undergone. So if something was done as per the previous legislation, which was valid, and now maybe under the new legislation it will become valid, repeal will have no effect on that. Is that clear? Repeal shall not affect any claim, privilege, responsibility, or debt obtained, ensued, sustained under any legislation so repealed. So any civil liabilities that were incurred in the previous legislation and that has been already determined. So let's say earlier there was VAT, there was service tax, things like that. And now we have CGST and SGST, correct? Now we do not have the concepts of VAT, service tax, excise, all of these have been repealed. So let's say under the previous excise duty act, you had incurred a liability for 1 lakh rupees and that has already been communicated to you. So will that debt be obliterated? No. So any claim, privilege, responsibility or debt that has been sustained under the previous legislation, that will not be affected by repeal. They cannot later on come and say that now excise act is not there, so my debt is also not there, or my liability for payment of tax is also not there. If it has been ensued, it will remain. Correct? Repeal shall not affect any punishment, forfeiture or penalty sustained with regard to offense committed. So let's say if a person was let's say there is a offense for which there was a punishment for 7 years in the 1956 Act, but it is 10 years in Companies Act 2013. A person was prosecuted for 5 years under Companies Act 1956. Correct? Can he be re-prosecuted for 10 years under 2013 Act? Because obviously new Act provides for 2013. 10 years of punishment? No. So repeal will have no effect on any punishment, forfeiture or penalty that is sustained with regard to any offense committed as opposed to any legislation. Repeal will not affect any inquiry, litigation or remedy with regard to such claim, privilege, debt or responsibility, or any inquiry, litigation or remedy may be initiated, constituted or insisted. So let's say there was some fraud that had taken in 1956 and litigation has been initiated under Companies Act 1956, it will continue to be investigated or completed under 1956 Act. But if the fraud was committed then, but it has come to the knowledge now, in that case it will be litigated under the new Act. But if the litigation has already started under the VAT Act or the Excise Duty Act, that will continue, that inquiry will continue as per the old legislation. So this is what is about the effect of repeal. Please mark this section as very, very important and let me know if you have any confusion here. Is this section clear? Effect of repeal, is it clear? So in this case, which was a state of Uttar Pradesh versus Hirendra Pal Singh, in this case, Supreme Court held that whenever an act is repealed, it must be considered as if it had never existed. Object of repeal is to obliterate the act from statutory books, except for certain purpose as provided in section 6 of the act. So what are those purposes? That the repeal shall not affect A, B, C, D, E and F that we have already discussed. Similarly, in Kolhapur Cane Sugar Works versus Union of India, Supreme Court held that section 6 only applies to repeals and not to omissions, and applies when the repeal is of a central act or regulation and not of a rule. So always remember the language, where any central legislation or any regulation. So the section 6 will come into force only when it is the repeal of central act or regulation, not the repeal of a rule. Is that clear? Similarly, in Navrangpura Gam Dharmada Milkat Trust versus Ramtuji Ramaji, court held that repeal of a provision is in distinction from deletion of provision. Repeal ordinarily brings about complete obliteration of the provision as if it never existed, thereby affecting all incoherent rights and all causes of action related to the repealed provision. While deletion ordinarily takes effect from the date of legislature affecting the said deletion, never to effect total effecting or wiping out of provision as if it never affected. So this distinction is important. It is important to remember the difference between omission, deletion versus repeal. Is that clear? Next is section 6A, which talks about repeal of act making textual amendments in act or regulation. So we are saying there is a act A which made amendments in act B. Okay? So this act A was used to make amendment in act B. Now this act A has been repealed. Then what will happen? That has been provided in section 6A. So 6A says, where any central act or regulation made after the commencement of this act repeals any enactment by which the text of any central act or regulation was amended by the express omission, insertion or substitution of any matter, then unless a different intention appears, the repeal shall not affect the continuance of such amendment made by the enactment so repealed and in operation at the time of such repeal. So if through Act A there was an amendment that was made in B, there was some insertion, some deletion or some substitution, the repealing of this act will not affect the amendments that were made here unless there is a different intention that appears. So there can be a different intention, but generally repealing of this act will not have any effect on the amendments that were made in this Act B. This is what is provided for in section 6A. Is this clear? Next is section 7, which talks about the revival of repeal enactments. Now the first thing is, can an enactment which was repealed be revived? Yes, they can be revived. But whenever it is to be revived, the reason for making that revival has to be recorded. So if you read, subsection 1 says, in any central act or regulation made after the commencement of this act, it shall be necessary for the purpose of reviving either wholly or partially any enactment expressed to state the purpose. So if a repealed enactment has to be revived, the purpose for its revival has to be mentioned. This section also applies to central acts that were made after 3rd January 1968 and, sorry, it will be 1868, and to regulations that were made on or after the 14th day of January of 1887. So applicability of this section is quite wide. Is it clear? Is this section clear? Please let me know if there is any confusion here. Guys, please let me know if there is any confusion here. Okay. Now, construction of references to repealed enactments, which is section 8. So if you know, Companies Act 1956 was repealed and Companies Act 2013 came into force. Now, the reference of Companies Act has been made in several other legislations, like there is reference of Companies Act 1956 in the income tax also, and things like that. So what will happen in such a situation? That is provided for in section 8. So section 8 says, where this act, central act or regulation made after the commencement of this act repeals and reenacts with or without modification any provision of a former enactment, then reference in another enactment or in any instrument to the provision so repealed shall unless a different intention appears, be construed as reference to the provision so reenacted. So even though if the necessary changes has not been made in Companies Act 1956, wherever a reference to Companies Act 1956 is made, it will be construed, it will be interpreted as a reference being made to the Companies Act 2013. So even though Income Tax Act says that for this provision you have to refer to Companies Act 1956, now, because 1956 has been repealed and reenacted, replaced by Companies Act 2013, you will automatically refer to Companies Act 2013. This is what is provided for in Section 8. Is that clear? Is this clear? So in this case, which is Gauri Shankar Gaur versus State of UP, it was held that every act has its own distinction. If a latter act merely makes a reference to a former act or existing law, it is only by reference, and all amendments, repeal, new law subsequently made will have effect unless its operation is saved by relevant provision. So if you remember, when the Companies Act 2013 was coming into effect in phases, there were some provisions of Companies Act 1956 that were saved for having effect. So this is what is said by the code. Is this clear? So section 5, 6, 7 and 8 is clear to all of you? Guys, any confusion till here? It is 3rd January of 1868. I think there has been some typo error in my presentation. It is not 3rd January of 1968. It is 3rd January of 1868. Guys, are we good till here? Please let me know. The typo is there in your study material also. It will be 3rd January of 1868, not 1968. Guys, are we good till here? Now, next section that we talk about, commencement and termination of time. So whenever you see provision saying from to, how do you determine the time here? So if you look at this example, if a company declares dividend for its shareholder in its AGM held on 30th September 2016, correct? Now, under the provision of Companies Act, company is required to declare dividend within 30 days from the date of declaration, correct? So how will you count the 30 days? So the counting will be start from the 1st of October to, so 1, 2, 3, 4, 5, so 1 to 30. So in this the series of 30 days, 30th September will be excluded and the last 30th day will be included. So this is how you count 30. So whenever there has to be a counting done from to, you exclude the first in the series of day and include the last in the series of day. So let's say you have to count 15 days from today. So what will be the 15 days from today? So today it is 27th Feb. So 15 days from 27th Feb, how will you count? 28, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. So when will the 15 days come to an end? On 14th March, correct? So this is how the calculation has to be done. So the first in the series has to be left and last in the series of day has to be included whenever you are talking about the commencement and termination of time. This is what is given in section 9. Is that clear? Is that clear? Next is section 10, which talks about computation of time. So section 10 says, whereby any legislation or regulation, any act or proceeding is directed or allowed to be done or taken in court, in office on a certain day, correct? Within a prescribed period, then if the court or office is closed on that day. So let's say the work had to be completed within 15 days from today, which is 14th March. Now the 14th March was the last day for doing it. Now that on that 14th March, on that last day, the office or the court is closed. Or last day of the prescribed period, the act or proceeding shall be considered as done or taken on due time if it is done or taken on the next day afterwards on which the court or office is open. So let's say the limitation period was coming to an end on 14th March. The court is closed for 14th and 15th March. So if you initiate the proceedings on 16th March, it will be considered as proceedings taken within the due time. So there was a case called K. Susla Ratnam versus Division Interior. It was held by Madras High Court that since the last date of the prescribed period was subsequent to the date of notification, declared to be a holiday on the basis of the principle laid down in this section, the last date of the prescribed period for obtaining the tender schedule was extended to the next working day. So this is how it happens. So there is always a period of limitation that you get to see for taking certain actions under the law. Let's say be it for filing of tender, be it filing for plaint in the court. So if the court is closed on that day, the office is closed in that day. If you take the action immediately on the next working day, it will be within the limitation. Correct? Yes, Srishti, there is a typo error. It will be 1868 and not 1968. Guys, I am repeating in this section, which was section number 7, it will be 3rd January of 1868 and 14th January of 1887. It's not 1968, it's 1868. There is a typo error in your study material. Guys, whenever there is such kind of tiny confusion or there is some typo error, you can always cross-check the section as such on the BEAR Act. You can always find the BEAR Acts on indiacode.nic.in and you can read section directly. So it is not 1968, it is 1868. There is a typo error there. Okay. Whenever section 11 talks about measurement of distance, so whenever distance is to be measured between 2 points, it has to be measured in a straight line on a horizontal plane. This is what is given on section 11. Section 12 talks about duty to be taken in pro rata. So whenever any new duties or taxes are levied, they have to be determined on a pro rata basis on the same rate or any gender. Next is gender and number. So section 13 says, whenever the provisions talk about male, it is deemed to include female also. And whenever the words include singular, it is deemed to include plural also. So if you look at here, in accordance with the rule, the words importing the masculine gender are to be taken to include female as well. So whenever you see the law refers as he or it says he, it is meant to include she as well. So the word his father and mother, as they occur in 125 of CRPC, has been construed to include her father and mother. And a daughter has been held to liable to maintain a father who is unable to maintain himself. However, where the usage of the word is such that it specifically conveys a specific gender. Let's say when the legislation uses the word bullock. So bullocks cannot be interpreted to include cows as well. So if the use of gender is such that it is a generic, then it will include both the genders. But if the usage of word is such that which is very, very specific, now the use of word bullock is extremely specific. In that case, it cannot be interpreted to include cow also. Is that clear? So whenever it says male, it includes female also. Whenever it says singular, it includes plural also, and same is the vice versa. Is that clear? Next section that we talk about is the powers and functionaries. So first is the section 14, which says power conferred to be exercisable from time to time. So this section says that whenever a power has been conferred on the person, he can exercise it from time to time. Every time before exercising that power, he does not need a permission. Once the power has been granted, he can exercise as and when the need arises. And this section 14, it applies to all central act and regulation that are made on or after the 14th day of January 1887. So every act or regulation that were made after 14 January 1887 to then this section 14 is applicable. Section 15 says power to appoint to include power to appoint ex officio also. Correct. So when a person has been given an authority to appoint someone due to the power of the office, he has the power to appoint ex officio also. So ex officio means by the person, by the position, by the virtue of one's position or office. Next is power to appoint to include power to suspend or dismiss. So section 16 says, like if the Chief Justice has a power to appoint a receiver, he also has the power to dismiss the receiver. So whenever someone has been given a power to appoint, similarly, the same person has the power to suspend or dismiss also. So whenever, let's say, a legislation does not specify that he will have a power to dismiss as well, but it will be interpreted so. So if the legislation just say that Mr. A has a power to appoint the subordinates, it will be assumed that he has the power to dismiss them as well. Correct? Section 17, 18, I'm skipping. You can read on your own. 19 also you can read on your own. Next is section 20 to 24, which talk about provision as to order rules made under enactment. Now, section 20 says, whereby any legislation or regulation, a power to issue any notification, order, scheme, rule, form, or bylaw is conferred, then expressions used in the notification, order, scheme, rule, etc. will have rule, form, or bylaw shall, unless there is anything repugnant in the subject or context, have the same respective meaning as in the act or regulation. So let's say there are several rules that have been made under the Companies Act by MCA. So the rules, the terms that have been used in those rules, in those regulations will have the same meaning as they have been granted for or provided for in the Act. This is what that section 20 says. So in the case of Subhash Ram Kumar versus State of Maharashtra, common English acceptation mean and imply a formal announcement of a legally relevant fact. And notification published in official gazette means notification published by the authority of law, and it is a formal declaration. This is not relevant. Don't read it. Next is section 21, which talks about power to issue to include power to add, to amend, vary, or rescind notification. So let's say if the MCA has been given the power to issue an order or notification, it is deemed that it also has the power to amend or issue order, rules, or bylaws as well. So 21 says, whereby any legislation or regulation, a power to issue notification, order, rule, or bylaw is conferred, then that power exercisable in the like manner and subject to the like section and condition, if any, to add, amend, vary, or rescind any notification, order, rule, or bylaw so issued. So these things can either be expressly provided for in law, or if it has not been provided for, it will be deemed to include the power to amend, vary or rescind notification. Correct? Is that clear? Now, next is section 22, which talks about making of rules or bylaws and issuing of orders between passing and commencement of an act. So here section 22 is talking about a situation where there is a gap between issuing and passing of enactment. Is that clear? So section 22 says where by any central act or regulation which is not to come into force immediately, conferred to make rule or bylaw or to issue order with respect to the application of the act or regulation, or with respect to the establishment of any court or appointment of any judge or officer thereunder, or with respect to the person by whom or the time when or the place where or the manner in which the fees or for which anything is to be done or regulation, then that power may be exercised at any time after the passing of the act or regulation. But rules, bylaws or orders so made or issued shall not take effect till the commencement of the act or regulation. So what this section says, there is a gap between passing of the act and commencement. So let's say the act was passed on, it was published in the official gazette on 1st August, but it will come into force only from 20th August. But the act requires that some rules have to be made, some regulations have to be made, or a court has to be established, or a judge has to be appointed, or officer has to be appointed. In that case, if the judge is appointed, an officer is appointed, a court established, that will deem to be valid. Also, the act or regulations, the regulations or rules or orders that are made for that act, even that will be valid. But those rules, bylaws or orders that have been made, they will come into force only after the enactment comes into force. This is what is provided in section 2022. Is that clear? Any confusion with section 22, guys? Any confusion with section 22? So next is section 23, which talks about provisions applicable to making rules or bylaws after previous publication. Mark this section as important. Section 23 says, where by any central act or regulation, a power to make rule or bylaw is expressed to be given, subject to the condition of the rule or bylaws being made after previous publication, then the following provision shall apply. So the act says that a rule has to be made or bylaw has to be made, but before the act or rule or the rule or bylaw is made, it needs to be published for the opinion of the people who are the stakeholders or from public. So you will often see the draft rules are published. So recently there was a rule which was made for Companies Act. Those were also published. So where such a requirement is there, section 23 will be applicable. Now section 23 subsection 1 says, the authority having power to make the rule or bylaws shall, before making them, publish a draft of the proposed rule or bylaw for the information of the person likely to be affected thereby. So this draft rules or bylaws will be published. The publication shall be made in such a manner as that authority deems to be sufficient, if the condition with respect to previous publication so requires, in such manner as the government concerned prescribes. So this publication can be done by the authority in whatever manner they deem sufficient, or as it has been prescribed by the government agencies or the authorities. Generally, publication is done in the English newspaper, Hindi newspapers, vernacular language newspapers. This is how publication is done. Now, along with the draft, a notice specifying a date on after which the draft will be taken into consideration as also to be provided. Further, the authority having power to make the rule or bylaws, where the rule or bylaws are to be made with the sanction, approval, or concurrence of another authority, that authority shall also consider any objection or suggestion which may be received by the authority having power to make rules. So whenever the authority has to make the rules, first they will publish the rules. The publication has to be done in the manner the authority deems fit or as prescribed by the government agency. Along with the draft rules or bylaws, notice has to be given that what is the time duration during which objections or recommendation or suggestions can be made, and when will the authority take those objections and suggestions into consideration. Now this authority will, if there is any other authority whose approval is to be taken, they will take into consideration the objections or suggestions that has been received. After that, the publication in the official gazette of a rule or bylaw purporting to have been made in the exercise of a power to make rule after previous publication shall be a conclusive proof that the rule or bylaw has been duly made. So once the objection has been made, whatever suggestions has been given, it is the power or it is the free will of the authority whether it wants to consider those suggestions or not. Whatever the scenario is, once those rules or bylaws are published in the official gazette, it will be deemed that they were duly made. Okay? So basically, there are guidelines for making rules or bylaws with previous publication. So first, there has to be a previous publication. The authority will give notice. They will consider the objection and suggestion. And after that, they will finally publish the rule or bylaw in the official gazette. And once it is published in official gazette, it will be proof that due process has been followed. Is that clear? Is my video still buffering? I think there must be some internet issue at your end because everything is fine here. Is this section clear? Section 23 is clear to all of you? Is this clear? Next is section 24, which talks about continuation of order, etc., issued under enactments, repealed and reenacted. So if there was orders that were issued under a previous act, but that act has been repealed and reenacted, then unless it is otherwise expressly provided, any appointment notification, order, scheme, rule, form or bylaw made or issued under the repealed act will continue in force and will be deemed to have been made under the reenacted law. This is what is provided for in section 24. Rest you can read on your own. There's nothing fancy here. Next thing that we talk about is section 25 to 30, which talks about recovery of fines. So wherever a fine has to be recovered as in CRPC or as per the Code of Criminal Procedure, then this section 25 comes into force. Next is section 26, which says provisions as to offense punishable under 2 or more enactments. So let's say a person has committed an offense, but that offense is punishable under two or more acts. It's not punishable under one act. Let's say there is an offense which is punishable under IPC also and under Companies Act also. So if a person has committed such an offense, then what will happen? That has been provided for in section 26. So 26 says, where an act or omission constitutes an offense under two or more enactments, then the offender shall be liable to be prosecuted and punished under either or any of those enactments, but shall not be punished twice for the same enactment. So usually what will you see when you would see that whenever the charge is being levied on the accused, it mentions like this: section 26, 420, this of IPC, section this of Arms Act, section this of Companies Act. So what happens? All the charges are levied, but he will not be prosecuted twice for the same offense. This is provided for in section 26. Next is section 27. Mark this as important. What is meaning of service by post? What is deemed to be service as by post? So section 27 says, because you will see this provision of service of post in various legislation. Where there is a requirement for service of notice, you will get to see this word service by post used. So section 27 says, where any legislation or regulation require any document to be served by post, then unless a different intention appears. How can the different intention appear? Different intention can appear as per the provision that has been provided in that legislation. So unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying and posting by registered post, and a letter containing the document to have been effected at the time at which the letter would be delivered in the ordinary course of post. So the delivery will be deemed to be effected at a time when in the ordinary course of post the delivery should have been completed. So three requirement: it has to be properly addressed, it has to be prepaid, and it has to be posted by registered post. So in this case, which is United Commercial Bank versus Bhimsen and Makecha, a notice when required under the statutory rules to be sent by registered post acknowledgement due is instead sent by registered post only. The protection of presumption regarding service of notice under registered post under this section of Act neither tenable nor based upon sound exposition. So where the law specifically says that it needs to be registered post with acknowledgement due, section 26, 27 will not come to the rescue, right? So this was all about the General Clauses Act 1897. I know I have rushed up a bit on few provision, but trust me, all the extremely important ones or the areas from where we largely get to see the questions or the ones which are very, very technical in nature have been duly explained to you. If something has been left behind, those are extreme basics and you can read on your own. You would understand that there was a paucity of time within which the content has to be completed. And I hope everything that we have discussed is clear to you. Let me know if you have any queries here. We can spare 5 minutes for taking up the queries on General Clauses Act if there is any. Now coming to the query of Parth. Parth was asking me that, ma'am, law is a broader concept primarily to maintain public order, and related rights or act is like a subset of law and is much more specific. My understanding to my query is that IPC is a law. Correct me if I'm wrong. So IPC is an act. It's act, but it is a law pertaining to the wrong done to the society. So just the way CPC, Civil Procedure Code, deals with the civil wrong done to the society. It contains the law, it contains the provisions for the civil wrong. IPC is an act. Indian Penal Code is an act which contains the law pertaining to the criminal wrong. Is that clear, Parth? Or the wrong done at large to the society. Similarly, Companies Act 2013 is an act which contains law pertaining to the operation and management of the company. Is that clear, Parth? With students repeating this to me that in the module it is given 1968. Let me tell you, in that section there is a typo error. It will be 1868 and not 1968. Any other queries here? So there are some questions that I have provided here. You can practice this on your own. There's nothing major that needs to be discussed. So with this, we have, I think we have finished paper 2, corporate and other laws. Companies Act was finished long back, and I think only GC Act and contract of agency was left behind. That is also completed. So I think this is my last class with all of you. I have tried my best to touch down upon all the topics that has been provided for in your syllabus, and apologize if 1 or 2 sections have been left behind. If after reading those sections, if you have any query, you can always drop to BOS, the Board of Studies, and we will address your queries. And I wish you all the best for your preparation. All of you study well. And I have noticed that few students are still not clear on the basic concepts. So I request you to reread and reread the study material that has been provided to you by the ICAI. And study well, study hard, stay safe. All of you take care, and all the best for your exam and your preparations. Thank you for your time and patience. And I look forward to see you guys in final. Okay? Take care, and thank you so much. Yes.